Hello, and welcome back to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. So, today we're going to be talking about how to file a VA disability claim. There's a few ways you can get started. A lot of people kind of get held up in their heads thinking they have to have everything perfect before they file. So, I want to kind of demystify some of what to expect, what you absolutely need, and what are the kind of nice to haves or good to haves if you can get the evidence, and walk you through it so that you can actually get started on the process and hopefully start getting the benefits that you deserve. So there's a few ways to get started. Kind of depends on your level of comfort and how tech savvy you are. One of the easiest ways to do it is to go on to the website and just upload a claim online at va.gov. And you just follow the prompts and answer the questions one at a time and upload documents that they request if you have them. That's a really easy way to get started. You can also work with a veteran service organization or veteran service officer like the DAV, Disabled American Vets, or American Legion, or VFW. There's a number of them out there. The key thing to remember is that nobody should ever be charging you for assisting with filing an initial claim or for filing a new claim. A VA does not allow accredited representatives or accredited agents to charge for initial filings. So anyone who does is kind of circumventing the VA's own regulations. And VA has a duty to assist you. It's not always the smoothest system. They don't always do their job correctly, but they often do get it right, or they get partially right the first time that you file. So you shouldn't be paying someone to help you file your initial claim. If you need help after you get your first decision, if you don't get the benefits that you think you deserve, if you got something denied, or if you got rated too low, then you might want to look into getting an accredited claims agent or an accredited attorney to help you consider your appeal options. But from the get-go, you can either file on your own or work with a VSO, veteran service officer, to get started. So online, and go into a VSO's office to get help, or you can download the application, print it out, or manually enter it on your computer into the PDF. And the form that you're looking for is called 526EZ. That's 526 Echo Zulu. So that's the form that you want to look at if you're filing a new claim for disabilities. Now, this form is different than the form that you're going to use if you were to file an appeal. Sometimes I've heard bad advice is out there on the internet, bad advice from some agents or VSOs that say, oh, just start over, just file a new claim. But if you get denied, you really do want to file a supplemental claim or a higher level review. You want to file an appeal of the denial. You don't want to just start over. VA will often kick it back if you refile a new claim after a denial. So you want to make sure you're filing the right claim. But if it's something that you've never filed for before, a 526EZ is the correct form to get started on. So really, that form is all that you absolutely need to get started. It's a pretty detailed form. It's going to ask you your branch of service, your social security number, your dates of service, your location of last separation. And a lot of that information that it's asking is to help VA gather the information they need to substantiate your service. So part of their duty to assist is they need to go get your DD. Now, if you have a copy of your DD-214 or you can easily access a copy of it, I'd upload that with my application because that's going to help kickstart stuff. It's going to help VA get moving on your application. But they do have that duty to help you. So if you're struggling to get a copy of your DD-214, I wouldn't let that be a barrier to getting started. I'd just go ahead and file and have VA go gather that information for you. This is especially true for survivors if you're trying to file a claim for a spouse after they've passed and you don't have their military service records. The more information you have, date of birth, social security number, branch of service, dates of service, that kind of stuff, is going to help VA gather that evidence for you. If you have copies of your service treatment records, VA should have those already. You really don't need to upload all of them. Sometimes it can be helpful if you have copies, if you've gone through it, to highlight certain pages on it. So if you know that you're filing a condition for your knee and you want to pull out the record from 1986 when you were in that boating accident and you got seen for your knee injury, go ahead and pull those out, highlight them, upload those to VA. But VA, as part of their duty to assist, they're going to pull all of your military personnel records and your service treatment records. So you don't have to wait. You don't have to request a copy of them. I think it's sometimes helpful to know what's in your record, but I wouldn't let that be a barrier to getting started if you don't have those records. So sometimes people say, yep, send in your service treatment records. If you have them and you can pull out key pages to highlight for VA, that can be helpful. If you have VA records, VA is going to have access to those VA records. So I'd only pull those out if you have specific pages that you really want to highlight for the reviewer, so they're not digging through hundreds of pages of records to find the key points that you think are important. Your private treatment notes, if you're treating outside of VA for a condition, if you've got a diagnosis with a private doctor, I would go ahead and pull those records and send in the relevant ones to VA. You can trigger VA to get those for you, but that's going to add delay in them processing your records. If you were diagnosed with PTSD and you're seeing a private psychologist or a private psychiatrist on the side, you want to get those records and send them in to VA. You can also review them before you send in to make sure that you're sending in the records that are related to the claims that you're filing and not just every medical record that you've ever had. We've got VA is starting to use AI to sort through records and stuff, but they have people and they'll get overwhelmed by looking through a lot of records and they might miss the important stuff if you just flood them with everything you have. Another thing that can be helpful when filing a claim, but again is not necessary, is what's called a nexus letter or an independent medical opinion. VA, as part of its duty to assist, if you enter evidence that you have a current disability and if there's evidence in your service treatment records or your military occupational specialty indicates that you might have had an injury or some sort of incident in service, VA is going to develop for what they call a C&P exam or a compensation and pension exam. So they'll go send you to an examiner, sometimes at the VA, sometimes, most often it's a contracted exam company. And that person's going to evaluate you, look at your records, and write up an opinion that says, yes or no, I think this condition was at least as likely as not, so approximate balance of the evidence, if this condition was related to service or began in service. Now, it's complex bureaucratic system. Some of the examiners are way better than others. So I get it that a lot of times people want to start off with a letter from their private doctor or a letter from a paid nexus company that kind of captures all of the pertinent medical records and reviews stuff in a light more favorable to you and kind of presents the best case forward, put your best foot forward to begin with. But if you have multiple conditions, to pay somebody to evaluate all of your medical records and all of your conditions when VA is going to do that anyway might be a waste of money. It might be that you're really only going to end up having to fight them on 1 out of the 5 claims you're filing. So I often recommend that people wait, depending on how many claims they're filing, wait and see what VA's first offer is, see how they do with the C&P exams, and then regroup, because you can always file a supplemental claim with new evidence. If you need to get a private nexus letter, you can add that in. If VA missed something or if their exam wasn't adequate, we can often get VA to correct those errors and get a better exam that asks the right questions or addresses the right evidence. So that's an option. A lot of people like to get nexus letters when they file their initial claims. It's definitely not mandatory. Another thing that an optional thing that you can include in your initial VA application is a buddy letter. So there's kind of 2 reasons to use buddy letters. One is to establish that something happened in service. If you don't have records, if you didn't treat for something in service, VA is going to be looking at, how do we know that this started in service or that this was caused by service? So getting somebody who knew you in service who can say, yep, I remember when we were running and this incident happened and we didn't have time to go sick bay because we were deploying the next day. And, I remember him limping for this long, or I remember her carrying her shoulder funny while we were doing this, and we'd help cover down on some of the duties so that she didn't have to miss the exercise. Buddy letters can be really helpful to establish that something happened in service if it's not in your service treatment records. The other thing that buddy letters can be really helpful at is establishing how severe a condition is now or the continuity of symptoms after you left service. So, yep, injured ankle in service. Did it get better right after service and it was just an acute injury? Or do you have buddy letters to show how you used to run lots of marathons and never ran marathons again after that injury and would constantly ice it and re-injure the ankle multiple times, what have you? So showing that what's going on now or showing kind of the history of the symptoms, those buddy letters can be really helpful. Now, that's stuff that might come out during your C&P, your compensation and pension exam. And as VA is developing it, so you don't necessarily need those, especially if something's well documented in your service treatment records, but they can be helpful pieces of evidence for VA to evaluate when they're looking at the totality of your claim. So to recap, you really only need the 526EZ, but there is additional evidence that can help your claim. VA is going to be asking you whether you think your condition was related to a toxic exposure. Under the PACT Act, which is the law that came into effect in August of 2022, VA is required to look more closely at toxic exposure risk activity, TARA, toxic exposure risk activity. So if you have a respiratory condition or if you have an autoimmune condition or something that you think was related to toxic exposure, then you want to check yes on that 526EZ or on your VA application. And that's going to trigger VA to pull up your records on where you served, what your specialty was, get an opinion on whether you're exposed to toxins, and then they're going to get a special medical opinion that asks whether your disabilities are related to that toxic exposure. Really important for Vietnam vets, anyone exposed to Agent Orange. You definitely want to make sure that you're checking that box. Another box that's kind of important to check when you're starting your application, you want to make sure you check the box at the top that you're doing a fully developed claim. Even if you're asking VA to help you pull certain records, that's going to be faster than if you check the box for standard development or standard claim. The fully developed claim, it's not going to stop VA from getting C&P exams. It's not going to stop them from requesting medical records if they need additional medical records or any other additional evidence. So that one is going to move faster. I think there's some misunderstanding about which box to check when you're filling out your initial claim. When you're listing your claims, VA is going to ask you why you think something is connected to service. So you're going to want to explain what happened, and how it's related. So if you have Parkinson's disease related to Agent Orange exposure, you were exposed to Agent Orange when you served in Vietnam, you're going to fill out those boxes and explain how your current Parkinson's disease is related to Agent Orange. That's a presumptive condition. We talked in the last episode about presumptive conditions. So that's really important to make sure that you're kind of telling VA why you think something's connected. If you're not really sure why it's connected, or there might be multiple reasons, you're probably going to want to list all of those reasons. And if you don't know at all, you can leave it vague and VA will have to develop for all of it. So I know some of my colleagues will say just leave it vague. I think it really depends on whether you sort of know why it's connected or if you're just guessing at why it might be connected, but you want VA to really unturn every rock, unturn every stone and figure out why something might be service connected. So for example, you might have migraines that began in service, but you're not sure if they were caused when you were exposed close to an IED blast and you have kind of a minor TBI, or if they're from the burn pits and the toxins that you were exposed to, or if they're aggravated by your PTSD and your tinnitus, and those service-connected conditions are just making your migraines worse. And maybe it's kind of some combination of all of those things that are causing and aggravating your migraines. You want VA to look at all of those possible causes for why you have migraines. So you can either leave it vague or point them in the direction of each of those theories of service connection is what VA is looking at. They want to know what the theory of service connection is, and then they'll develop medical opinions. They'll develop the evidence and ask you questions related to each of those theories. So you want to try to help VA navigate a path that's most likely to result in them finding a connection between your current disability and service. If you're worried about all the evidence that you have to gather, but you want to get started, one tip is to file an intent to file. So you submit an intent to file. It's really just, you can go on to va.gov. It's a simple form you can download and send into VA. But once they get that form that shows an intent to file, you can even just start an application, and if you don't finish your application, that counts as an intent to file. And what an intent to file does is it kind of bookmarks that day, because when VA pays you, assuming that you win your cases, that you win your claims, they will pay you back to the date that you filed your claim. So you're going to get back pay. If it's going to take you a while to gather your evidence and you're not ready to file yet, you put in an intent to file. It serves as kind of a placeholder. So as long as you file a claim within a year of that intent to file, and then you win, VA can pay you back all the way to the date of that intent to file. So it can add up to an extra year of back pay if and when you win your claim. So it's really important. But that ITF, that intent to file, gets used up with the first claim that you file. So if you put in an intent to file and then you file a claim for your knee a couple weeks later, and then 6 months later you file a claim for your sleep apnea, VA used up the intent to file with your knee claim, and it's not available to get you an earlier effective date for your sleep apnea. So it doesn't apply to every claim that you file within the first year. It only applies to the first claim that you file after the intent to file, as long as that's filed within a year. So it's nice to kind of bunch, if you're able to, wait until you have the evidence that you want to submit, your package that's ready to go for all of your claims, and file them all on a single 526EZ or a single application for disability benefits. I often tell people, obviously you don't want to exaggerate your conditions. That's fraud, and VA is investigating fraud. You don't want to say things that aren't true. But more often what I see is veterans minimizing their symptoms. They're kind of used to their conditions and they're like, I'm fine, I'm fine. That's just the way life is. You don't want to minimize your symptoms. You do want to explain to the examiners, and you want to explain to VA the severity of your symptoms, how it impacts you. I know that can be challenging, especially with mental health conditions, but you do want to kind of dig deep and consider how these conditions are impacting you. So once you file your claim, VA will send you a confirmation that they've received your claim, and then they'll begin to develop the evidence. So if you check the boxes that you were exposed to toxins, they're going to do that TARA memo. They're going to do the development to see if they can confirm that you were exposed to toxic exposure, risk activity, a TARA exposure. They'll pull, if they don't already have your DD-214, they'll work with the National Personnel Records Center to get your DD-214, get your military personnel records. That can take some time. If this is the first time that you've ever filed a claim, VA coordinates, with an outside agency, the National Personnel Records Center, to get your records and get them into the file. So it can sometimes take a while to kind of kickstart your claim as VA is gathering those initial baseline records. Once they've done that, somebody will review it. And if they think that there's enough evidence that something happened in service and you have a current disability, they'll start scheduling those CMP exams. So you'll start getting notices from, it could be from VA. Usually those come from the exam company that they're contracted with. And each exam company has slightly different processes for contacting veterans. They're definitely getting better than they were back even 5 or 10 years ago. They're much better at contacting veterans, but sometimes it's by phone, sometimes you get an email or a text message, and sometimes you get a letter in the mail or a certified letter that says you've been scheduled for an exam, and it will tell you where to show up. And you don't usually get much say in where and when the exam is. If you can't make that exam, you can reach out to the exam coordinator, and at least one time they'll work with you to try to reschedule something. Ultimately, if you can't make the exams, if something comes up and you have to reschedule multiple times, you might have to reach out to VA to get those exams rescheduled, but they will reschedule them for you, especially if you have good cause for not being able to make them. It's not super easy. It's not a super nimble system. You're dealing with VA requesting exams from a third-party contractor who's coordinating with you, the veteran. So if something kind of gets missed and has to be rescheduled, it can add delays to to your claim processing. So you do want to work with them to get those scheduled to attend the exams. Sometimes they'll do what's called an ACE review or a medical record only review. And the examiner might call you if they have questions, but they might not need to examine you. They can just look at your records to see if you have this condition and see whether make an opinion on whether it's related to service or not. So in those cases, you may not even have to show up for the exam. VA will at some point usually send you what they call a 5103 notice. And that's your kind of last call for alcohol at the bar. Like it's your VA's last call for evidence. If you have anything else you want to send into them, they're requesting that you send it in at that point before they make a decision. It doesn't necessarily mean that they're missing information. If they are missing specific things, they'll tell you what they think they need. If they say, well, you said you treated with Dr. Smith for your back, please send us those records, or please send us an authorization for us to request those records. Then you want to do that and get the records from Dr. Smith so that VA can continue processing your claim. But if they're just asking, if you have anything else to send us, please send it in. You don't have to do that. You can sign the 5103 notice and send it back, or you can just wait for the 30 days to expire. Either way, VA is probably going to wait those 30 days anyway before they decide your claim. And then you're waiting for your decision. Once you get your decision, that's when you want to evaluate, do I think they rated me correctly? Do I think they denied stuff that they shouldn't have denied? And at that point, you might want to reach out to an accredited claims agent or an accredited attorney who can help you evaluate your decision, figure out if VA got everything right and you got all the benefits you're entitled to, or if there's stuff that VA missed and stuff VA got wrong that you might want to file an appeal, and what the best kind of appeal is, what the best strategy for pursuing your appeal rights are. So if you find this information helpful, if you're interested in learning more about the VA process, please like and subscribe. And if you have suggestions for additional episode contents, please put those in the comments. Thanks so much. We'll see you next time.